So after you've gone through the claims process and the insurance company has either made you an offer of zero or an offer that's not fair, your next option is to evaluate your case for litigation. When you go into litigation, a new lawsuit is filed with the court, the defendant is served with the lawsuit papers, and this begins the discovery phase of litigation. And the purpose of discovery is to uncover as many facts as possible about your case. There's typically two forms: written discovery and depositions. Written discovery, you can require this other side to answer certain questions and also produce certain documents. Depositions are the first chance you get to tell your story, but it's also an opportunity for your attorneys to determine what witnesses and the other party is going to say when you get in front of a jury at trial. Additionally, if your case involves a child or a death, the South Carolina Rules of Civil Procedure require that that settlement be approved by the court. This means that you actually have to go for a live hearing, typically in circuit court, lay out the terms of the settlement, the amount of the recovery, and ask the court to approve the settlement as being in the best interest of the child or in the best interest of the decedent's estate.
If you've been injured in a car wreck and the insurance company is not agreeing to pay you for your medical bills and your other harms and losses that you sustain, such as lost wages, the medical bills, pain and suffering, permanent impairment, long-term problems, then you have an option of going forward and pursuing your case in litigation, which means filing a lawsuit. Your claim will be presented to a jury, and this is assuming that the case is not resolved by mediation or negotiation through the course of litigation. Not every case goes to trial. As a matter of fact, most cases these days do not actually reach a jury. But if the case is going to go to trial, you will go through the discovery process known as depositions, interrogatories, production of documents. The next step will be mediation, which is mandated by court rules. And then when the case goes to trial, the case is presented to a jury, which can be an extensive process. And without counsel who knows what they're doing in the litigation process, your chance of getting a fair result before a jury is not good. And I will tell you that in this day and time in our society, you have to convince all 12 jurors that you should win, that you should receive a favorable verdict, and how much compensation you can receive. And that's a real uphill battle. And it's a long process that usually will take from the time of injury to the end of the case in litigation anywhere from 2 to 4 years.